Hi, everyone. People are trickling in. I'll try not to bore you too much after lunch. All the blood flowing through to your stomach, and try my best to not have your eyes glaze over too quickly. But estate planning is not the most exciting, but it is very important. Like Kim said, my name is Mathew Jacob. I am the founder of the Jacob Law Firm. I've been practicing law for 27 years now. And one of my practice areas of focus is estate planning. I also do business law and commercial real estate, but I really enjoy the estate planning component as well. And just want to, impart some, I don't know if you call it wisdom, but just things that I've learned over the years on the different types of estate plans, how people go about transferring their assets in different ways, what works, what doesn't work, that type of thing. A little bit more about me. I am a member of the club. My wife, my kids, I have 2 kids in college and 1 in middle school. My wife is a practicing physician here, and we love the club. Thank you all for coming. Now, what I want to do, like I said, is try to explain things in as much plain English as possible. Try and skip over the legalese, but sometimes, lawyers like to use big words for some reason, so I'll try to avoid that. All right, well, there's I don't know what that is, but that was the first thing. There we go. So, what is an estate? Estate is everything you own. A lot of people are like, well, why do I need an estate plan? I don't have a big estate. It's your bank accounts, it's your home, it's your cars, it's your life insurance. And sometimes people don't think that the value of their life insurance is included in the value of their estate. Like, I'll never see a dime of that money. It's paid out after I die. Well, the government doesn't see it that way. They see it as part of your estate when you pass. So, sometimes when people have insurance policies that are in the millions of dollars, that could create an estate tax issue. So something to be aware of. But it also includes your retirement, your personal effects, jewelry, everything that you've worked so hard to accumulate over the years. And, you work so hard to get these things in life, and it's important to set things up to where it transfers to your loved ones as seamlessly and as cost-effectively as possible. So, we're going to go over some ways to go about doing that. Why do estate planning? I may look like a tech guy, but I'm not. All right. Why do estate planning? After death, you have the ability to control who receives your assets and to minimize legal fees and estate taxes and things of that nature. What's also included in estate plan, so typically when you're thinking about a will, you're thinking about your death. Well, there are other documents that come along with an estate plan that cover incapacity. So you're still living, but who's going to be the people that make decisions on your behalf, both financial and medical? Who needs estate planning? Everyone. Anybody that's an adult. So, sometimes people are like, well, I don't really need an estate plan. I'm still young. Or I just don't have a whole lot of assets. But It covers everybody, seniors, people with young families. So seniors with adult children and grandchildren, as well as people with young families and, single individuals, as well as even college kids. You may have kids in college, and, people are like, well, why does my kid need an estate plan? It's more important for the kids because now that they're over 18, if something were to happen to them, car accident, and somebody needs to make medical decisions for them, you need to have those documents in place that allow you to make those decisions for your kids. So if you know anybody that has college-age kids, or if you guys have kids that are in that age range, that is an important thing to talk about. Also, there's a document, or there's a federal law called FERPA. And again, because the kids are adults, they don't have to tell you what their grades are, even though you're paying for it, their education. So you can fill out a FERPA release that would give you the ability to access their grades. Want to give some examples of some estates that, some people that you may have heard of, what happened in their estates, just to give a general sense of what could happen as far as the complexities, as far as the costs and things of that nature. So Elvis, when he passed away, I think it was 1977, he was worth $10 million, which that doesn't sound, you would think that his estate would be worth even more than that, but it definitely is now. But his gross estate was worth $10 million. He had some debts that had to be paid off. The administrative, legal, and executor fees were almost $2 million. And there were estate taxes that had to be paid that were almost $3.5 million. So $10 million is reduced down to less than $1 million after everything was said and done. And he had a will. So, but it didn't include a lot of the provisions, and I think he didn't choose the right type of estate plan that would have avoided a lot of these costs. So, something to think about. The next one is Groucho Marx. Groucho Marx, he also had a will, but a will, as I'd mentioned before, it only covers death. Doesn't do anything with regard to incapacity. So he was declared incompetent by the court and lost control of his assets, unable to make personal decisions. It became a very public thing, and his name was dragged through the mud. And it was very expensive to do all of that because he didn't have documents in place that named specific individuals to make these medical and financial decisions for him. So the court had to make those decisions, and there were a lot of people who felt like they should be the one making it, so it ended up being protracted litigation to decide who that person was going to be. So when should you plan? Now. You should plan now. You should plan while you have the ability to plan. Think ahead. You have the capacity to do it. You have the time to think about who you want your specific assets to go to, how you want it to go to them, and there's no better time than present. Now, we would all do different things. We would all rather do different things. We would rather go to a Taylor Swift concert and spend $5,000 for a ticket in the nosebleeds, or go to the World Series or Super Bowl, wherever. And, obviously, people have no problem spending thousands of dollars on those things. But, everybody knows that they need to do an estate plan, but it's always one of those things where I'll get to it when I get to it, right? It's lower on the priority list. Let me get through all these other things I need to do first. And, oftentimes it ends up, it's too late. Something happens, you become incapacitated, or you pass away, or a loved one passes away, and then it becomes a big issue. So now we're going to get into the different types of estate plans. There are 6 primary. Will, we talked a little bit about that. Doing nothing, and that's what most people do. I think the statistics are that about 70%, 75% of people don't have even a simple estate plan. There's joint ownership, giving away your assets while you're alive, beneficiary transfers, and revocable living trusts. And I'll go into examples of each of those. With a will, you express your wishes on who you want your things to go to when you pass away, and you identify who you want the executor to be. The executor is the person who carries out your wishes, is the person appointed by the court. Now, this only controls assets titled in your name. These are probate assets, so your bank account, your home, your investments, things of that nature. Other types of things like your retirement, life insurance, those are things that can transfer outside of probate, non-probate assets. Now, when you have a will, you have to go through probate. A will, the court first has to determine that the will was executed with all the formalities that are required under the law, and and once the court does that, the court will appoint the executor to carry out the wishes that were stated in the will. So there is court involvement required whenever there's a will. And that court requirement is called the probate process. It's a legal process. You have to validate the will, you have to pay off debts, and distribute assets according to the will. And it's the only way to change legal title. So Kim, a realtor, she wants to sell a house for a widow whose husband passed away. Title is in both of their names, husband and wife. There has to be a document that identifies the surviving spouse or somebody else as the executor of the estate. That's the only person who actually has the authority to transfer the title, file a new deed with the court records to show that the surviving spouse is legally entitled to, the full ownership of the home. It's just a little illustration of what happens when you go through the probate process. All of your different assets go through the probate court. You got your probate fees, you pay the lawyer, you pay the court costs, and you may have to pay some estate taxes, and then whatever is left goes to the heirs. Wills, like I had mentioned, they don't cover incapacity. You have to have separate documents for that. A durable power of attorney for financial decisions, a medical power of attorney for medical decisions. Whereas with a trust, and I'll get into what a trust is later, a trust actually covers both death and disability. So, again, when you don't have documents in place, you have to go through the courts to name somebody to serve as the guardian to make decisions for that individual who became incapacitated. And again, that's very expensive, time-consuming. It's a public record, and it's just frustrating on many levels. That's when you get a durable power of attorney to make those types of decisions. Doing nothing, it's easy now to do nothing, but it's really hard on you if you become incapacitated, and it's hard on the family after you pass away if you don't have anything in place. You'll have to go through the probate process, but there is an additional step. When you don't have a will, the court will have to go through an additional process to determine who the rightful heirs are. So the court appoints another attorney. So now there are two attorneys involved. There's one that's representing the person who is trying to get through probate, and then there's another attorney that represents the unknown heirs. So you're having to pay two sets of lawyers. And when you don't do anything, the courts decide who gets your stuff. And it may end up being people that you don't want it to go to. So that's why it's really important to identify who your beneficiaries are. Again, if you're incapacitated, same thing. The court controls who's going to take care of you and who gets your assets. Now, joint ownership, there's something called a joint ownership with right of survivorship. I don't know if you guys have heard that. But basically, it says that if you and your spouse own a home together, and you own it jointly with the right of survivorship, whoever outlives the other person gets, in this example, gets the home, which is all well and good, and that's what you want, but it doesn't stop there. So Tom and Ann, they're owners. Tom passes away, Ann inherits Tom's share in this joint, owned jointly with right of survivorship title. Ann passes away, and then Ann's heirs inherit. But what if Ann then remarries, and then they have title owned jointly with right of survivorship? Well, then Dan inherits it. And the kids that Tom and Ann had together are completely disinherited. So you want to put something in place if there is a second marriage, that you protect the children from the first marriage. Giving assets away. Sometimes people, when they get older, they become less inclined to handle their financial affairs, and sometimes what they do is they just have their children handle everything. And sometimes either the kid will convince them, or they'll decide on their own, well, I'm just going to put the title to this house in your name. Well, what happens there, if the kid then decides to sell the house, you have no control over that. But it also has a tax implication. Whenever, if you were to give away your house to one of your children when you're still alive, there is no step up in basis. So basically what that means is the basis is whatever you bought that house for. So let's say you bought the house for $100,000 and then sell it for $350,000, which we probably need to double or triple that now. Kim will tell us. But the gain is $250,000, and then the capital gain tax on that, would be, what's in this example, $50,000. Now, if that house is transferred to those same children after the owner passes away, there's a step up in basis. So now the basis is whatever the house is valued at the time the person passed away. So there would be no tax owed on that because there's no recorded gain. The fifth plan out of 6 is beneficiary transfers. So you all probably have 401ks, IRAs, retirement accounts, life insurance, those types of things, where you have filled out beneficiary designation forms and you've identified who you want your things to go to. If you're married, your spouse, and then you have children, you name them as secondary beneficiaries. Well, oftentimes there may be some issues with the forms. Maybe you didn't fill it out at all, or you filled it out incorrectly, or there was a change. Somebody that you named as a beneficiary passed away, or has become incapacitated, or if you some people sometimes just put, for their beneficiary on a beneficiary designation form, they just said, I want it to go to my estate. Or if your child is a minor. Well, all those examples, a court is going to have to be involved. Now, the last plan is keeping control. It is a revocable living trust, and in my view, it checks most of the boxes of all the different types of plans. This one is oftentimes, one of the preferred methods of transferring your assets. And how much time do I have? A couple minutes?
Maybe 5 more minutes.
All right. Now, when you set up a revocable living trust, you and your spouse, you guys are the grantors of the trust, you're also the trustees of the trust. So you maintain control over the assets that you transfer into the trust because you are the trustees. And you also identify who the beneficiaries are. It's called a revocable trust because you can make changes to it at any time. It has specifics as far as what your wishes are, how you want things to be handled after you either become incapacitated or pass away. So this is just an example. Earlier I showed that funnel when you go through the probate process. When you set up a trust, you can avoid the probate process altogether. And the quickest way that I can explain that is, again, with home ownership. If you own a home, you own it with your spouse, and the title to the house is in your individual names, you got to go through the probate process to get that title changed to the surviving spouse's name. When you create a trust, you transfer the title from your individual names into the name of the trust, and that trust is going to continue to exist after the first spouse passes, after both pass away. So there's no need to go through the probate process to change legal title because you've already done it during your life. And that applies to other assets that you own as well. So you control the inheritance even after you pass away. So if in an example of either a will or when there is no will, whoever your beneficiaries are, they get whatever assets are distributed in a lump sum. So they may be a raging teen, just rebelling for independence. And we all make different decisions at age 18 than we do at 35 or more. When a kid gets an inheritance in a lump sum at a young age, they may end up spending that money on things that you wouldn't necessarily agree with. So there are ways to structure a trust to where the kids get payments over the course of time. So what I typically do is by age 25, they get a third, by 30, they get another third, and by 35, they can have full access to the funds that were left to them. So that's what would be done. They would be, you can control the access to the funds after you pass away. Then, if you do have a kid that has special needs, you can include provisions in there that would allow them to continue to get governmental benefits by setting up the trust. And you can, as far as minors are concerned, you can name a trustee to make sure that they're taken care of while they're minor, and if you don't have that set up, the court will just put the money into a court account and then distribute it once the kid turns 18. And then the last thing said, it protects from creditors and predators. So anything that you leave to your loved ones after you pass, that money is protected. So as long as that money is held in that trust and kept in that trust, creditors can't go after it. So if your kid gets sued, car accident, or they get into financial issues, whatever is held in that trust cannot be seized in a judgment. It also protects from divorce. If your kid gets married, the marriage doesn't work out, they get divorced, whatever money that you leave to them that's left in a trust will not be subject to a divorce decree. As soon as they take that money out and put it into, a joint bank account, it becomes community property and is subject to be divided. All right, so living trust summary: avoid probate at death, prevent court control of assets, provide maximum privacy, because when you file things in probate, it's public record. It allows for quick distribution of assets. You don't have to go through the probate process that could take months and sometimes years if there's a dispute. And you're able to keep assets in the trust. And it prevents unintentional disinheriting, like we were talking about in that joint ownership with right of survivorship. And you can reduce or eliminate estate taxes if you're married, because there are provisions that you can put in place that essentially doubles the estate tax exemption. Right now, the estate tax exemption is really high, and it doesn't really affect most people. But that's subject to change. Right now it's 15 million. It's about to be 15 million per person starting in 2026. But then it's a highly politicized issue, so it could be repealed or changed by the next administration. So it's always something to keep an eye on. Disability documents real quick: medical power of attorney, advance directive for health care, HIPAA authorizations. Medical power of attorney, you've determined who you want to make medical decisions for you. Well, if you don't have a HIPAA authorization, that person that's making medical decisions for you may not have access to your medical records, and they need that to make informed decisions. Advance directive for healthcare is if you're ever in a terminal or irreversible condition, you make the decision now while you can to either be kept on life support or taken off life support, so to where your wishes are met instead of somebody else having to make those decisions for you, or there being a dispute among family members on what should be done. This is just, I'll wrap it up now, but a lot of people decide, well, I can just get forms online, or I can do ChatGPT or whatever. But, the difference between that is essentially the legal advice that you get from an attorney versus forms.
So, you can do it, but you have to be careful. You have to know what the provisions mean. And it's good to have that explained to you. That's essentially it. There are ways to protect real estate investments through different types of LLCs. And these are some other topics that sometimes I go over. But that's it. Thank you guys so much for listening. Hopefully you learned something. If you have any questions, feel free to give me a call or shoot me an email. Thank you.